Dear students, good morning. I hope you all are in fine health and you are taking your studies very seriously. Dear students, till now we have revised 4 chapters of civics and today we will be revising 5th chapter of civics. And as you all know that civics portion is very important for us. From our 80 marks board questions about board question paper, we will be getting 35 marks question paper from civics portion. So civics is very important and please revise this chapter and revise other chapters also. This chapter is interconnected with chapter number 4, that is the Supreme Court. So before revising this chapter, we are to go by the syllabus of this chapter: High Courts, composition, qualification of judges, appointment, jurisdiction and functions, which covers original jurisdiction, appellate jurisdiction, revisory jurisdiction, the power of judicial review and court of record, enforcement of fundamental rights and writs. So majority portion is similar with chapter number 4, that is enforcement of fundamental rights and writs and revisory jurisdiction. Okay, judicial review, the power of judicial review is always also similar with the power of judicial review of Supreme Court. And from subordinate courts, we are to study the distinction between the court of district judge and sessions judge. Next is Lok Adalat. From Lok Adalat, we are to revise the meaning and advantages of Lok Adalat. Okay, so we will revise this chapter like the other chapters from questions. So first question is, the High Court is the highest court in the state. With reference to it, answer the following questions. Question A: who appoints the judges of High Court? Mention any 3 qualifications to be a judge of High Court. Okay, the answer to this question is given on page number 249. Like the judges of Supreme Court who are appointed by the President, the judges of High Court are also appointed by President of India. Okay, but the judges of High Court, they are appointed in consultation with the Chief Justice of the Supreme Court and Governor of the concerned state. In the case of Supreme Court, the judges of Supreme Court are appointed by the President in consultation with the Council of Ministers and the Chief Justice of the Supreme Court. High Court, the judges are appointed by President in consultation with the Chief Justice of Supreme Court and Governor of the concerned state. Qualifications. First qualification, it is similar with the judge of the Supreme Court. First is, person should be a citizen of India. Okay. Second is, he should not be over 62 years. Means 62 years is their retirement age. Third is, he has held a judicial office in the territory of India for at least 10 years. It means that he has been a judge in one or the more subordinate courts for more than 10 years. Okay, or he has been an advocate of a High Court for at least 10 years. In the case of Supreme Court, this qualification, that is second part of point number 3, it is same. Means a person should have been an advocate of a High Court for at least 10 years. Means for minimum 10 years, more than it can be 20 years, 25 years also. But the maximum age to become a judge of the of High Court is 62 years, and in the case of Supreme Court it is 65 years. Okay, next question is, Mention any three cases which come under the original jurisdiction of the High Court. We are to write any three cases which come under the original jurisdiction of the High Court. The answer to this question is given on page number 250 and 251. So what is original jurisdiction? Original jurisdiction, the meaning is similar with the meaning of original jurisdiction in case of High Court. Okay, the cases which come to the Supreme Court directly, that is the power to hear and decide the cases in first instance. So what are the cases which come under original jurisdiction? Point number 1, relating to state revenue and its collection. Second, wills, divorce, marriage, company law, contempt of court. Third point, power of judicial review. Fourth point, enforcement of fundamental rights. Fifth point is election petition challenging the elections of members of parliament and state legislative assembly. In case of Supreme Court, it is the election dispute of president that is heard by the Supreme Court, and in case of High Court, it is the election dispute of members of parliament and members of state legislative assemblies. Next question is, elaborate any 4 points of differences between court of district judge and court of sessions judge. So we are to write any 4 points of differences between the court of district judge and court of sessions judge. The answer to this question is given on page number 255. Court of district judge. It is the highest civil court in the district. Sessions court, it is the highest criminal court in the district. Okay. District court, highest civil court. Session court, highest criminal court. District judge, as the name of the court, it is presided over by district judge. Sessions court, it is presided over by sessions judge. Okay. Third point, the district judge and additional district judges are appointed by governor in consultation with the Chief Justice of the High Court of the concerned state. Similar is the case of the session judge. The session judge and the additional session judge are appointed by the governor in consultation with the Chief Justice of the High Court of the concerned state. Fourth point, the district judge decides civil cases relating to land, property, money transaction, arbitration, guardianship, marriage, divorce, and will. And the session judge decided criminal cases like murders, theft, dacoity, pickpocketing, etc. Means the district court decides civil cases and the session court decides criminal cases. Okay, fifth point, the district judge act as a deputy commissioner and district collectors, but the session judge does not perform any such administrative functions. So these are the differences between the court of district judge and court of session judge. Usually the judge is one person. Okay, when he entertains civil cases, he is district judge, and when he entertains criminal cases, he is session judge. So judge is one person, but there is a difference between court. Okay, district judge, court of district judge, it is the highest civil court, and that is, it is the highest criminal court. Next is, second question is, the judiciary is the system of courts that interprets and guards the Indian Constitution. With reference to the High Court, answer the following questions. Question A, mention any 3 types of cases which come under the appellate jurisdiction of High Court. We are to write any 3 cases which come under the appellate jurisdiction of the High Court. Appellate jurisdiction, the meaning is similar to the appellate jurisdiction of the Supreme Court. It means that High Court has the power to accept appeals against the decisions of the district court in civil as well as criminal matters. Okay, means we are to go to the High Court by way of appeal against the decision of the district courts. in matters such as civil and criminal cases. And in the case of Supreme Court, we are to go to the Supreme Court against the judges delivered by High Court in cases relating to civil and criminal matters. Okay, so what are the cases which come under original jurisdiction of the High Court? First is civil cases. Okay, only those cases which are decided by the district courts are under the jurisdiction of the High Court concerned can be brought to the High Court by an appeal. It is the most important point. It states that the courts which are under the jurisdiction of the High Court concerned, only those cases and only the appeals against the judgment of those cases can be heard by the Supreme Court. For example, if the case is decided by the Amritsar Civil or District Court, you can go only to Punjab and Haryana Court. Punjab and Haryana High Court. You cannot go to the Delhi High Court or Allahabad High Court or Shimla High Court. Okay, so we can appeal against the cases to only the High Court concerned and not to the other High Court. Second is criminal cases. In the criminal cases, we can go to High Court against the appeal of the session judges. Okay, when we can only go to the Supreme Court against the judgment of the session court if the imprisonment given by a session judge exceeds 7 years. Second point is we can go to the against the judgment of an assistant sessions judge or the chief metropolitan magistrate or the judicial magistrate where the sentence of imprisonment exceeds 4 years. Third point is against the state when the order of acquittal is passed by a session judge. You need to be more clarified about this point. Suppose a case is settled by a session court, and in that case session court acquits that person. Okay, and you want to go to High Court, you cannot file an appeal against the session judge. You can only file a case against the state. Okay, fourth point is a sentence of death must be confirmed by the High Court before it can be carried out. The session judge has the power to give a death sentence, that is death penalty, to any person, but the death sentence that is passed by the session court, it has to be confirmed by High Court before it is carried out. It is not that the session court has given a death sentence to a person on, for example, suppose on 7th January and on 8th January the person is to be hanged. No, this is not the case. The death sentence which is given by a session court, it has to be confirmed by the High Court before it is to be carried out. So these are the 4 criminal cases which come under the appellate jurisdiction of the High Court. Next question is, it has 2 parts. We are to question number B, explain the power of judicial review. Explain the power of judicial review. The power of judicial review is similar to the power of judicial review of the High Court. It states that if any law, executive order, or an ordinance passed by the state legislature or any authority infringes the fundamental rights or contravenes any provision of the Constitution, the High Court can declare it null and void. Okay, so this is the power of judicial review, which states that if any law or any order or any ordinance of the legislature or the executive order is against the provisions of the Constitution, the High Court can declare it null and void. Similar is the case of Supreme Court. Okay, it is the power of judicial review. Next is question C. Explain the following terms. First is court of record. What is the meaning of court of record? Similar to the meaning of court of record of High Court. Supreme Court. What does the court of record means? It means that its judgments and orders are preserved as a record to be referred to by its courts in future cases. They can be produced as precedents. The law laid down by the High Court is binding on all subordinate courts in the state concerned. What is the meaning of court of record? It means that the judgments which are delivered by the Supreme Court, they can be produced in the form of evidence or testimony. They are in the form of precedents, means they can be produced before any subordinate court, and in the similar case the subordinate court has to give similar decision. Okay, this is the court of record. But this jurisdiction is different from that of Supreme Court because the decision given by the Supreme Court is valid in the whole of country, but the decision given by High Court is valid only in the state under its jurisdiction. Second is the High Court can punish anyone who commits the contempt of its order. Means the High Court, if any person he is not obeying the decisions of the High Court or he is showing any kind of disrespect to the High Court, he can be punished by a High Court. Next is advisory jurisdiction. The advisory jurisdiction, as the name implies, to give advice. The High Court can advise any government department, legislature, or the governor if they seek it on constitutional as well as on other matters of law. Their advice is not binding on the agency seeking such advice. In the case of Supreme Court, the president can seek advice from the Supreme Court, but that advice is not binding on the Supreme Court. And in advisory jurisdiction, the governor, the legislature, or any state government department can seek advice of the High Court. The advice given by the High Court is not binding on the agency or the person or any authority which has sought such advice. Okay, it is also similar to that of Supreme Court. Next is our MCQs. Before MCQ or before answering to some MCQs, we must go through the advantages of the Lok Adalat. So the advantages of Lok Adalat is very important point. First is it plays important role in the settlement of family feuds. Feuds mean small disputes between the neighbors and minor cases of assault and injury. By setting the disputes through compromise, the Lok Adalat always settle the dispute by compromise. Second is it delivers fast and inexpensive justice. Third is the Lok Adalat reduces the workload of other courts. Fourth is it promotes social justice by providing legal aid to weaker sections of society. So these are the advantages of Lok Adalat, and we are to solve one or two MCQs from by referring to these advantages. So these are the MCQs. The answers to these MCQs you will send in the group between 5 p.m. and 6 p.m. today when the privacy of the group is opened. First is civil cases, ratio court of district judges, double ratio criminal case, ratio dash. A option revenue court, B option family court, C option session court, D commissioner's court. It means that by referring to the first phrase, that is civil cases, court of district judge, you are to answer the criminal cases. Okay. Second question is second MCQ, which states that when the High Court reviews any judgment made by it to remove any error, it falls under dash jurisdiction. A. Advisory, B. Revisory, C. Original, D. Appellate. So in this case, you are to write the jurisdiction when the High Court reviews any judgment made by it to remove any error. What kind of jurisdiction is this? Third MCQ is we are to write the advantage of the Lok Adalat. First is more than 90 statement states more than 97.64 lakh cases settled in the first National Lok Adalat of 2023. It is a report that is given by NALSA. Which advantage of the Lok Adalat is most highlighted in the above headline? So we are to answer this statement. We are to write the advantage of the High Court when Lok Adalat when it is settling more than 97 lakh cases. First advantage is it saves money. B. Speedy justice. C. Works on compromise. D. Reduces burden on High Court. You are to tell me the advantage of Lok Adalat when it is settling more than 97 lakh cases. Fourth is the High Court feels that there has been blatant injustice in a case solved by a lower court and transfer the cases to itself to check the judgment. Which jurisdiction it is exercising? So case is the High Court has transferred the case to itself. So which jurisdiction it is exercising? Option A, revisory, B, advisory, C, original, D, appellate. So these are the 4 MCQs and you are to send me the answers of these MCQs. Dear students, we have revised civics and I already told you that from civics portion you will be getting near about 35 marks paper in your board exam. So please revise all these chapters. Thank you so much.